Good morning, Judge Stevens.
Good morning.
It looks like we have everybody, including the court reporter, present, so we can start whenever you're ready.
Okay. Good morning. This is case number 17-00068 and 18-00129. Counsel, could you please state your appearances for the record?
Good morning, Your Honor. This is Jeff Donahue from the White Schneider Law Firm on behalf of plaintiffs.
Morning, Your Honor. Neil Giovanatti from the Attorney General's Office on behalf of the defendants.
Morning, Your Honor. My name is Courtney Kissel from Dykema Gossett. I'm appearing on behalf of the Michigan Catholic Conference and the Michigan Association of Non-Public Schools as amicus.
Good morning, Your Honor. Dan Karakyan, also for the plaintiffs.
Good morning, Your Honor. Ariana Pellegrino, also for the plaintiffs.
I appreciate that the plaintiffs have three lawyers. Are three of you speaking?
No, Your Honor, I'm going to be handling the argument. Thank you.
This is the date and time set for a motion for summary disposition filed pursuant to MCR 2.11C10. There are two issues before the court. Which costs identified by the Department of Education are eligible for reimbursement under the applicable statute, and whether the appropriation made under 3881752B runs afoul of the Constitution, Article 4, Section 10. You may proceed.
Thank you, Your Honor. I'm going to address the first issue, whether or not the mandates meet the Court of Appeals test. As you've seen, the parties have submitted a joint status report which has the mandates listed, and the parties have agreed regarding which mandates meet the Court of Appeals test, which mandates do not, and a third category is really which mandates are not reimbursable because they do not impose any sort of health or safety or welfare mandates on the non-public schools. Your Honor, the parties are not trying to hide the ball here. Frankly, when we went back after remand and we looked at what we were going to do, initially, we believed that we were going to have to engage in discovery and that we were going to have to start deposing people. And when we looked at the mandates and had the discussion with defendants, we thought that it was far simpler to simply say, here's what they are, to see if the parties agreed on what met the test and what did not, and had discussion concerning that. And after we went through that process, we came to the conclusion of what you see in front of you. So there's no mystery here how the parties went about this. And we thought that was the most efficient way to present the issue before the court, is to file that stipulation in front of you. Of course, if the court says it would like to have full briefing on each one of those mandates, for a full explanation as to why the parties came to that conclusion. That, of course, is what we will comply with. But that is why we did what we did. Responding
Counsel,
to the,
I understand that the parties to the case engaged in some good faith effort. Was this stipulation served on the amici?
no, Your Honor, it was filed with the court, and I believe amici received a copy of it. Obviously, they've responded to it. So I believe that they've seen it. I don't want to speak for them, but I believe they've seen it because I believe they addressed it in their most recent filing.
And would counsel for the amici stipulate that you have had an adequate opportunity to be aware of this proposal, sufficient to respond to this court in full?
Yeah, Your Honor, we have seen it. We did see it when it was filed with the court, which is why we filed our brief in July as well as the one in October to address the distinctions we see. But we have to review.
Thank you. Counsel, could you go further now on behalf of the plaintiff?
Yeah, yes, Your Honor. I'm going to move on to the second issue. The second issue is whether or not the appropriation under Section 152 B violates Article 4, Section 30 of the Constitution. It is our position that it does. The question is whether or not this appropriation is for a private purpose. The legislature has said it was a public purpose, but as the Supreme Court said in a 1966 case, that does not necessarily end the inquiry. The court has the obligation to test the question and to see whether or not that meets the constitutional standard. In our opinion, it does not, because the means that the legislature has chosen to make this appropriation make that appropriation unlawful. The phrase ends justifies the means is something we're all aware of. The defendant here basically says the means don't matter. And we believe that that is wrong. The means do matter. The Supreme Court was very clear in the 1966 decision that you have to look at the means of which how the legislature is putting the money into private hands. And in that case, the Supreme Court said that the appropriation was unlawful. Now, the state, as well as amici, have criticized our analysis and our reliance on the 1966 case, saying that that case is outdated, that there is other case law from the Supreme Court which has walked away from that decision. I think it's important to point out that the Supreme Court has never overruled the 1966 decision. They've distinguished it, but they've not overruled it. And the obligation of this court is still to review that constitutional standard and look at the means as how the court, as how the legislature made that appropriation. And I would dare say that it's very apparent that if you look at some of the things that the state, as well as the amici, are saying in their briefs, that under what they say should happen, clearly it would not be a private purpose for the state to just simply reimburse parents for attending private schools. And because they say, well, the means that how it gets there doesn't matter, it's just that it ends up being for a public purpose. Well, we think that analysis.
Could you address Grebner?
I'm sorry, Your Honor, I missed what you said.
Could you address Grebner?
Yes, Your Honor. In Grebner, I think that the Supreme Court looked at the prior case law and said, we are going to take a broader view of public purpose, and we are not going to look at what maybe be called a narrower view of public purpose as was in 1966. As you know, that the Michigan Supreme Court is not the same Michigan Supreme Court that sits now. I also think that that is a misguided view of how the Constitution should be read. And that simply because there is some case law that decides we believe that the public purpose and absolute deferral to the legislature is in order is not necessarily in conjunction with the Constitution. So
You believe that Grebner said absolute deference?
No, Your Honor, I didn't say absolute deference. I mean, that might have been an exaggeration on my part, but it in fact turns into an absolute deference because, if you read it, they say, we are going to say if the legislature says it's a public purpose, then it is. And I think that that's wrong, because I think that if you look at the history of this particular case, you can see that where the legislature passed this amendment, clearly in the face of a blatant constitutional amendment saying it can't, and as when the governor signed this, the governor at the time clearly said, well, I'm not so sure this is Constitution, but I'm going to sign it anyways and let the courts figure it out. I think
but counsel, the court in Grebner gave a reason as to why affording private parties access to information at public expense was appropriate. Now, whether we agree with it or not, I believe they said that the political parties served a public purpose integral with the exercise of the franchise, and that therefore this particular appropriation served that same public purpose. Education is a public purpose in the Constitution of the state of Michigan and generally in public policy in the United States. If in fact the legislature believes that paying certain costs from the public treasure accomplishes the purpose of affording education to children, what is it that I look to say, well, yeah, these things may in fact serve the public welfare and health and safety, and yes, they are going to children in education, but because the educational institution to which these children attend is private, that defeats or attenuates the public purpose of education and instead makes it the private purpose of promoting parochial education in private schools.
I understand what you're saying, Your Honor, and there are two separate arguments here. We're really just talking right now about the Article 4, Section 30 issue, which is only about whether or not the legislature passed it by 2/3. For example, they did pass the appropriation for the, I believe the 21-22, or maybe the 21-22 appropriation was passed by 2/3. So we wouldn't be talking about this particular constitutional argument with regard to that appropriation. We still take issue with whether or not it meets the Court of Appeals test under the other part of the Constitution. But for this particular analysis, all we're looking at is whether or not it is the private means that the legislature is putting the money, and that's where it has to pass it by 2/3. If it did pass it by 2/3, we would not be talking about this particular argument and not be having this analysis. I think it's a different analysis, Your Honor, with regard to the other section of the Constitution, and they use some of the same words, but it's a different constitutional analysis. And I think in this particular situation, it's the means you have to look at of how the legislature is accomplishing it, and they are clearly putting this money right in private hands, and that's why it makes it a private purpose, not a public purpose.
Well, that's an argument. Is there anything else that you would wish to say to augment that which you've written?
I don't think so, Judge. Thank you.
Okay. Thank you very much. On behalf of the Attorney General. So on behalf of the state of Michigan, please.
Morning, Your Honor, and I apologize off the top here. I'm fighting the end of a cold, so if I mute suddenly, that just means I'm about to start coughing. On the Article 4, Section 30 issue, we think the court, as set forth in our brief, we think the court's analysis, as just proposed to plaintiff's counsel, is correct. As the public purpose is not narrowly defined, the Supreme Court has explicitly said the term public purpose should not be narrowly construed by the courts. And the fact that the funds ultimately end up in the hands of a private entity is not pertinent. Since the 1967 case that plaintiffs rely on, the Supreme Court has repeatedly upheld appropriations that ultimately end up in the hands of private entities, finding that regardless of the fact that the money ends up in private entities' hands, it still constitutes a public purpose, assuming the funds actually do have such a purpose. And the courts also have repeatedly, and we cite a whole host of cases in our brief, emphasize the strong deference to the legislature. Here, the statute itself, subsection 7, specifically says that the appropriations under the statute at issue here are intended for the public purpose of ensuring the health, safety, and welfare of children in non-public schools. So it even is more narrow than the kind of broader public purpose of education. It's specifically for the health, safety, and welfare of children, which plaintiffs in their brief concede is a public purpose. What is this means-based analysis that plaintiffs rely on simply isn't the law. As I think the court referenced in Grebner, Grebner says explicitly whether there's better means of achieving a public purpose is a matter for the legislature, not for the judiciary. So it kind of cuts the means-based analysis off.
Well, but your colleague says, well, maybe it's okay generally to send this money, but when you do it, you have to do it by a 2/3 vote because of the entity to whom the funds are going.
Your Honor, if that were the test, I think that the 55 years of Supreme Court case law that has come down would be incorrect. And obviously that can't be the case. The 1976 case, which is confusing because it's advisory opinion about the 1975 Public Act, goes through a quite thorough analysis of how to analyze what is and what isn't a public purpose, Your Honor. And it explicitly says that simply because and I'll read the quote, I'm sorry, this is from a different case, this is from Airlines Parking. The fact that defendants benefit, defendant being a private entity, benefit from a state appropriation does not necessarily imply that the appropriation lacked a public purpose. And that's, again, regardless of whether there's a 2/3 legislative vote or not. So it's beyond simply the fact that the funds may end up in private hands really is not the test for the court. It's a deference test. If there's questions about deference, then we look to, and this again is from the 1976 case, the focus of the analysis on whether there's a clear relationship between the goal of the appropriation and the public welfare. And here,
Okay, but here's what I heard your colleague say is that there are 2 steps of analysis. One is whether or not these funds can be transferred, period. And the second is if they are to be transferred into the hands of a private entity, then what level of assent must the legislature give for such a transfer? Can you focus my attention on any case that either accepts expressly or rejects that proposal?
that 2-step process that the court mentioned,
Yes, sir.
I'm not aware of a decision that explicitly lays out that 2-step process. I'm not sure that is the test. And as I understand it, that first question would go to the other constitutional issue, the Article 8, Section 2. And the second question would actually be the
Go to Article 4,
Section
yes.
30. Yeah, so focusing just on the Article 4, Section 30 question, the plethora of Supreme Court case law since 1967 pretty clearly supports that these funds here are for a public purpose. The deference afforded to the legislature, the fact that the funds regardless of the fact that the funds end up in a private entity. And again, I think it bears particular note. It's particularly noteworthy that plaintiffs concede in their briefing that the appropriation is for a public purpose. They just contest the means of getting to that public purpose, but that would functionally add a requirement to Article 4, Section 30 that isn't even in the plain text of the constitutional provision. The constitutional provision does not require that funds be appropriated for a public purpose and that they be advanced through a public means. It simply requires that the funds be appropriated for a public purpose, which I think is, as plaintiffs have conceded, is the case here, Your Honor. I could talk in greater detail, Your Honor, but I think our briefing kind of lays out this point in quite a bit of detail. If the court has further questions on the Article 4, Section 30 issue, I can address them. Briefly on the Article 8, Section 2 issue, I think, Your Honor, as plaintiffs' counsel mentioned, the parties each conducted an independent analysis, and we came up with the same analysis applying the Court of Appeals test to the 40 different items that were listed on FDE's reimbursement form. There really isn't a controversy at this point between the parties on that issue, and thus, Your Honor, it's unclear why the court would need to weigh in. If the court feels it needs to, I would second what Mr. Donahue says, that the parties, I think, are open to providing additional briefing to provide the analysis to support their joint status report, the identification of each of the items into passes the Court of Appeals test, doesn't pass the Court of Appeals test. And then that third category we mentioned, we would propose that, given that this is plaintiff's claim, that they would file the first brief and we would respond accordingly. But again, because there isn't a controversy between the party, it seems unnecessary for the court to weigh in at this point. Unless the court has further questions, Your Honor, we would rest on our briefing.
Okay, thank you. On behalf of the amici.
Good morning. Thank you, Your Honor. We just want to start by saying we appreciate the court's inclusion of us in this argument today. I'll be really brief. I think our briefs do cover everything pretty comprehensively, but just a couple points. Just to start with the Article 4, Section 30 argument, we agree with the state's position. We articulate that in our brief that we just filed last month. We think that there is no constitutional issue there. So I won't go any further on that. With respect to the first issue, we just want to emphasize that the Court of Appeals remanded this case back to examine the items that might be reimbursed in light of the Court of Appeals opinion. And the parties have submitted this proposed list. We were not a part of the discussions or the analysis between the parties, but we did receive a copy.
So, Ms. Kissel, can you slow down a little?
Sure. Sorry. Excuse me. We did receive a copy of the list, but we were not. We did not participate in the discussions between the parties.
You did not participate in what?
The discussions between the parties. The plaintiffs have asked this court to grant summary disposition based on that stipulated list. And we think that is not appropriate, given that it's really a question of law. And respectfully, plaintiffs' counsel suggested that there's no mystery here, but we disagree. We think that there is, because the analysis is missing, and we, as we articulate in our July brief, have a different analysis. And I think the most glaring inconsistency between the Court of Appeals opinion and the list can be found with MCL 380.1179A, which is the provision that addresses the EpiPen, the provision that requires EpiPens to be included at the schools. And the Court of Appeals opinion specifically addressed that particular provision. And so that is on the parties list as not being reimbursable because it's not a health, safety, or welfare mandate. Respectfully, we disagree with that analysis. We think the Court of Appeals decision is also contrary to that finding. And we have articulated our analysis for all the mandates in our July brief. And we think that granting summary disposition based on a stipulated list would be inappropriate.
Ms. Kissel, you're talking so fast, I don't even understand what you're saying. Can you slow down, please?
Yes, I
I
apologize.
didn't understand your words.
I apologize.
Articulate our analysis for all mandates in our July brief, and we think.
Yeah, we think that granting summary disposition based on a proposed list would be inappropriate, and it's inconsistent with the Court of Appeals decision.
So, counsel, you agree with the majority of the stipulated lists as to those things that are allowable, right?
We do agree with what the parties have articulated as reimbursable, yes.
And you have given the court other things which you say are also reimbursable. Is that correct?
Correct.
So you would not be opposed to, I mean, it's like your colleague when sometimes we speak in absolutes when we don't mean it. You believe that the court should grant partial summary disposition as to those stipulated items, but you would have the court make a ruling of law as to those that you have put forth. Is that right?
The court could do that. I mean, obviously,
well, what else would I do?
I would say that the parties should brief the analysis on their conclusions to grant summary disposition.
Okay, you know what? It's when I have three parties that agree to something, asking those three parties to tell me why they agree strikes me as an incredible waste of energy, particularly since I can read too. So why I'm unclear as to what would be the benefit of briefing those things for which there is an agreement between the three of you.
I understand, Your Honor. I do think it's a strange posture here. This is a unique situation where the state and the plaintiffs now agree on.
It's not just the state and the plaintiffs. You agree.
We do.
You have some other things that you think should be included. I don't have a problem with that, but there is not an ounce of disagreement between the three of you. And I've actually read the provisions, and if forced, I would find that the things that they say are reimbursable. While I don't agree with the Court of Appeals decision, but under that decision, they're reimbursable. Okay. I'm not going to make anybody brief what everybody agrees on. Now, you've got a list, and I don't believe, and it could be because of the way our filing system runs, that I don't have it. But did we get a reply in writing from either the state of Michigan or the plaintiff as to those additional items which you suggested should be reimbursed?
No, Your Honor. I believe they footnoted in their briefs that they would be willing to respond, but they did not file anything in response.
Okay, I just want to make sure, because sometimes things are hiding in Lansing from me. So, okay, do you want to address Article 4?
No, Your Honor. Just to say we agree with the state's position, and we think that there is no constitutional issue.
We're back to the plaintiff, and we're back to the plaintiff principally on. You could say some more about Article 4 if you like, but I think you've killed a tree or two for that one. But can you address directly the additional items that your colleagues, or on behalf of the amici, believe meet the Court of Appeals test?
Thank you, Your Honor. I will. Specifically about the EpiPens, which is MCL 380.179-117A. The reason why the parties, at least why the plaintiffs feel it's not covered, is because the section 1179 parens 7 specifically states who has to comply with that mandate. And it does not say that mandate has to be followed by non-public schools. So it is correct that the Court of Appeals used the EpiPen as an example of what I think inarguably is health and safety of students. But the court didn't go further to look at specifically in the statute, in that mandate, who had to comply. And when you look at it, non-public schools do not have to comply. So that's why plaintiffs made that finding. I believe the state made that same finding, and that's why it is non-reimbursable.
Okay, and with no disrespect, I think you've reached that same conclusion.
Yes.
Okay, I
Yeah.
think I'm the person who has to make those findings, kind of things. And I understand your position about that, but I was inarticulate in my question. My question should have been relative to the list of things that the amici have suggested the parties have reached an erroneous conclusion on. How would you suggest that the court resolve those? It does appear to me that as much as I do not want to ask you to brief more, that we probably need to come up almost like we would have a privilege log. At the end of the day, I'm going to have to look at all of these things that you say are not, that they say are, and then just make a ruling one by one. And in order for us to have a full record, I believe we need to have in writing the reasons why the parties do not believe these things are eligible. I believe that they come in two groups. One, they don't have to do them. And two, they don't relate to public health and safety. I think that's basically what you're going to tell me. But I think I have to make you tell me that. Can you think of a way out?
I cannot, Your Honor. We would be glad to do that.
Really? You'd be glad?
Anything to help out, Your Honor.
Okay, you'd be willing to do it. But
Yes.
sir, how much time do you think that it would take you to give such a response?
Your Honor, I would say that it would not take us more than, I believe we have a lot of this, charted out. And so I don't think it would take us more than, I would just say 2 weeks, and that might be too much time. But I would say
and I'll tell you what, counsel, I don't need a brief. I really need a chart.
Yep.
Because it's going to be, it doesn't meet this part, it doesn't meet that part, it doesn't meet the other part. We don't need footnotes, I don't need cases.
Your Honor, I would endeavor to do exactly that, to be very succinct and very direct and give you, as you say, something like a privilege log, but in a chart form that we would say, this is plaintiff's view as to why, and then we would send it to defendants. And of course, have them do what they want to do. And then, of course, if you'd like us to, we'll have amici serve it on amici and respond to what amici said about those mandates.
I would really like this case done before the winter solstice.
Yes, Your Honor.
Can that be accomplished? Can I allow, frankly, off the record, the counsel for the parties and the amici, can you give me a schedule so that I get this by December 10th? And then I can give you a Hanukkah, Christmas, Kwanzaa, winter solstice gift of your ticket to the Court of Appeals?
Yes, Your Honor.
Okay. Because we know that's where it's going, but and from there to the Supreme Court, if they believe that it's an issue of public importance on which they should make a ruling. Is there anything else that you think we need to address today, Mr. Donahue?
No, Your Honor.
And on behalf of the state, Mr. Giovanni?
Nothing, Your Honor.
This is Monday. Do you believe that you can work this out by Wednesday in terms of the schedule? Because as long as it gets to me by the 10th, how you parse the time between the two of you, between the three interested entities, is of no moment to me. I will tell you that as erudite as you are, we will not have oral argument on this final question.
Your Honor,
Yes.
just a point of clarity. So the amici have kind of said their piece on these issues. If you want to hear from the parties, I think that makes sense. Am I hearing you right that you would like further response from the amici? As I see this, maybe it's plaintiffs file something, the defendants respond, and then you have something from all three of the entities.
What would I like? If I told you what, it would defeat the purpose of having the three of you talk if I'm going to tell you what you're going to do.
I guess I'm asking the question.
Traditionally, if this was done in the form of, it is the amici that are putting forth a position. You are responding to that position. In almost any trial in which, or any fact finding in which a party puts forth a position, they tend to reserve rebuttal, which does allow for a reply. But what if the three of you cannot reach a decision on it, I will. But December 10th is the deadline. So if you find maybe what I need to do, gosh, yeah, I will. I will have a notice sent out for a status conference at 11 o'clock on Friday. And if you have not reached a conclusion about the schedule, that would give us a touchback date, and I'll just give you a schedule. But I am very confident that you can come up with a reasonable schedule, since we're talking about putting in inputs in a chart.
I believe we can work it out, Your Honor, and we will endeavor to do that as soon as we can.
Okay. Thank you. Anything else from the amici?
Oh, thank you, Your Honor.
Thank you. With that, we will be in recess. Thank you very much. Have a good week.
Thank you, Your Honor.